Welcome to the debate. Our focus today lands squarely on, well, one of the most fundamental yet maybe surprisingly unresolved questions in American law, the constitutional definition of income under the 16th Amendment and this persistent legal idea of realization.
Right. And this is, effectively the constitutional power source for the entire modern federal government. The tension really lies right there in the amendment's wording. It grants Congress the power to tax incomes from whatever source derived without apportionment among the several states.
And to understand why that seemingly simple sentence is just so complex, we have to look back to the 1895 Supreme Court case, Pollock v. Farmers Loan Interest Company. That decision had effectively declared taxes on income that came from property, like rents or dividends, to be direct taxes.
And under the Constitution, specifically Article 1, Section 9, those direct taxes must be apportioned among the states based on population.
Which, for a national tax on personal income is just administratively absurd. It basically crippled the federal government's ability to levy an income tax. So the 16th Amendment, ratified in 1913, was the direct fix for that. Our central question today is this: does the amendment constitutionally require that a financial gain has to be definitively realized, actually received or enjoyed by the taxpayer, to be taxed as income without needing apportionment?
Meaning, does the gain have to sort of materialize, detach from its source, before the federal government can actually tax it?
Exactly. I'll be arguing that the amendment grants Congress a pretty broad pragmatic authority to define and tax income, which minimizes the constitutional importance of a really rigid realization requirement. It favors flexible fiscal policy.
And I approach this more from the constitutional constraints perspective. I'm going to maintain that a strict realization requirement is actually a necessary constitutional safeguard. It's essential, really, to distinguish permissible, unapportioned income taxes from what would be unconstitutional direct taxes on just raw property or wealth itself.
Okay, so position statements. The 16th Amendment, it engineered this monumental shift in American government. Before 1913, the federal government relied mostly on highly regressive tariffs and excise taxes. The income tax made possible by this amendment allowed for the shift to a progressive system. This was championed by those, seeking to place a fairer burden on the wealthy. And this change was the financial backbone, really, that enabled the centralized, powerful modern state we know, capable of financing 2 world wars and, all the complex programs of the 20th century.
Pacific Railroad back in 1916. They acknowledged the amendment didn't give a new taxing power, but simply removed the Pollock barrier, that specific barrier of apportionment, from taxes classified as income. The underlying taxing power itself, that remains Article 1.
And that flexibility is key. We see this broad interpretation, I think, confirmed by the Supreme Court's quite narrow decision recently in Moore v. U.S. The majority upheld the mandatory repatriation tax, the MRT, which was a one-time tax on realized but undistributed corporate earnings of certain foreign companies. They relied heavily on the, quote, long-standing practice of pass-through taxation.
That's certainly a powerful reading of Moore. But I think it potentially overlooks the fundamental necessity of defining the word income itself, constitutionally speaking. The amendment grants power to tax incomes from whatever source derived. That word, derived, it seems to imply a necessary separation from the source, a materialization of the gain,
A materialization which, in the MRT case, had already happened at the corporate level, right? Even if the cash hadn't landed in the shareholder's pocket yet.
But the argument that realization is required is rooted in the structural purpose of the Constitution itself, specifically to prevent the federal government from just directly taxing wealth or property without that check, that political check of apportionment. Justice Thomas, in his dissent in Moore, strongly asserted realization is the crucial legal tool for separating the taxable event, the income, from the untaxable capital, the source.
But why must that barrier be so absolute?
Doesn't a really rigid rule like that kind of hobble Congress's ability to address, sophisticated modern financial structures? Things get complicated.
Well, because if Congress can bypass realization in tax gains that are merely theoretical or unrealized, like say the unrealized appreciation of stock, or gains that are still locked inside a corporate entity that the shareholder literally cannot access, it essentially obliterates the distinction between a permissible income tax and an unapportioned and therefore unconstitutional direct tax on property. And this concern isn't new. It's precisely what drove the court in Eisner v. Maycomber way back in 1920 to strike down a tax on certain stock dividends. They deemed them property, not realized income. So let's dig into this constitutional structure for a moment. The original direct tax clause required apportionment by population. Now, for a nationwide income tax where states have wildly varying populations and wealth concentrations, apportionment is just an insurmountable hurdle. And this was intentional, arguably. Many founders wanted direct taxation to be rare, cumbersome, reserved for emergencies maybe. The 16th Amendment only carves out an exception for income, so if we discard a firm realization requirement, Congress could potentially redefine income to mean any mere increase in property value, unrealized wealth, and thereby achieve an unapportioned wealth tax, violating that core structural limit.
I have to push back on that a bit. I'm not convinced that Maycomber and this sort of looming threat of an unapportioned wealth tax are the necessary lens for viewing the 16th Amendment today. Look, the courts have already established that Congress has what's often called plenary power to tax. And the landmark case Commissioner v. Glenshaw Glasgow in 1955 really solidified a more functional economic definition of income. It looked for, quote, accessions to wealth clearly realized, and over which the taxpayers have complete dominion.
But that phrase is still in there, clearly realized.
Yes, but I think it functions differently now. It's not necessarily a rigid constitutional source test derived from the amendment itself, but maybe more of a doctrinal standard developed by the courts. It's meant to ensure administrative workability and, avoid truly arbitrary taxation. Glenshaw Glass moved the focus away from the source, that rigid Maycomber view, and more toward the economic gain itself. So if Congress taxes income that is realized, even if it's only at an entity level and then attributed to the taxpayer, it arguably falls within that framework. Furthermore, the true check on legislative abuse, as Justice Jackson argued in her Moore concurrence, is often the political process. If Congress imposes overly burdensome or genuine and arbitrary taxes, the remedy is found at the ballot box, not solely by judges imposing some inflexible constitutional test from 1913. And speaking of Moore, the narrowness of that holding is, I think, crucial evidence against an absolute realization rule. The court upheld the MRT by confirming that attribution is permissible in certain contexts. The MRT taxed realized corporate income by, permissibly attributing it to the U.S. shareholders, even though those shareholders hadn't personally received a cash distribution. This seems to confirm that realization doesn't always have to occur strictly at the shareholder level.
Attribution is indeed common, I grant you that, but you're overlooking the crucial fact that these corporate earnings had been realized somewhere along the line, at the corporate level.
Absolutely. And this practice isn't new. Look at Subpart F of the tax code, which was enacted way back in 1962. It taxes U.S. shareholders on certain income realized by controlled foreign corporations, even if it's undistributed. And this historical practice has consistently withstood constitutional challenge. That seems to show that the constitutional definition of income can accommodate complex, modern, anti-abuse regulations and these corporate structures.
That's a compelling argument about precedent, but I must challenge that reading of Moore as a complete green light for flexible attribution. We really need to look closely at Justice Barrett's concurrence. She explicitly stated that realization is in fact a constitutional requirement under the 16th Amendment. Now, while she concurred with the majority's judgment in that specific case, she raised pretty profound concerns that any attribution must still be, quote, cabined by the Due Process Clause to ensure it is not arbitrary.
But she accepted the outcome, didn't she? Which suggests the MRT itself fell on the constitutionally safe side of that line, even for her.
Well, she accepted it primarily, it seems, because the Moores themselves had conceded that Subpart F itself was constitutional. They weren't challenging that baseline. Her focus was really on the necessary nexus, the connection. She strongly implied that Congress cannot simply attribute any corporate gain to a shareholder without a genuine, non-arbitrary legal relationship. And this, I think, reestablishes that the constitutional definition of income remains fundamentally limited. Perhaps most telling, though, is that the majority explicitly declined to address whether realization is a constitutional requirement for all income. They sidestepped the big question, the taxation of pure unrealized gains. The court avoided the issue entirely, which strongly suggests they recognize the potential constitutional weakness of a fully flexible, anything-goes approach to defining income.
So when we look ahead, this flexibility in defining income, it really does create a serious potential, maybe a threat, of overreach. If Congress is allowed to tax, say, unrealized capital gains or just general wealth by simply labeling it income, then that historic compromise tied to the apportionment rule is basically discarded, and that potentially makes the federal government's taxing power nearly boundless.
Are you suggesting the judiciary is somehow failing to perform its duty here to check Congress? Or wouldn't check them?
I'm suggesting the judiciary must be careful not to erode the very tools necessary for that check. The Supreme Court itself signaled that these old characterization questions, about direct taxes, are still relevant when it favorably cited both Pollock and Macomber in the 2012 NFIB v. Sebelius decision, the ACA case. It demonstrates that this constitutional line between property and income, often guarded by the realization requirement, is still actively being considered for the future. Without that realization buffer, we could be just one simple act of Congress away from an unapportioned federal wealth tax.
I think that relies maybe a bit too heavily on a worst-case legislative scenario rather than judicial and political reality. Historically, the purpose of the 16th Amendment wasn't just to raise revenue, but to help create a sustainable, progressive fiscal state. The Supreme Court in Moore was, I think, highly pragmatic. They were acutely aware of the massive economic and legal risk of invalidating, quote, vast swaths of the Internal Revenue Code. The court expressly stated its ruling does not address hypothetical taxes on holdings or wealth.
That statement was perhaps largely self-preservation, avoiding a bigger fight.
Perhaps, but it still demonstrates institutional restraint, wouldn't you say? For over a century now, the unapportioned income tax has been the government's reliable revenue engine precisely because it's viewed as constitutionally safe. Congress has relatively little incentive to enact truly questionable taxes on unrealized wealth that would almost certainly risk judicial repudiation, especially when constitutionally safer revenue raisers are readily available. And the practical definition provided by Glenshaw Glass, those accessions to wealth, clearly realized, it seems to provide sufficient judicial guidance already to draw a line between true income and untaxed property. So in conclusion, the 16th Amendment, I believe, achieved its primary purpose. It enabled a robust, powerful federal government financed largely by a progressive income tax structure, freeing it from the constraint of apportionment for income. While the precise boundaries of income remain subject to legal interpretation, and they certainly will, especially as our financial world gets ever more complex, the historical and judicial acceptance of Congress's broad taxing power suggests that a truly rigid, absolute constitutional requirement of realization is likely incompatible with the necessary functions of the modern fiscal state the amendment helped create.
I understand the pragmatic appeal, I really do, of maximizing congressional flexibility. But the debate, at its heart, boils down to whether the constitutional text imposes meaningful, enforceable limits on that power. The ongoing disagreement, even among the Supreme Court justices themselves in Moore v. U.S., more than a century after ratification, clearly demonstrates that the line between taxable income and untaxable property remains, well, precarious. Until the courts definitively resolve whether realization is a necessary constitutional prerequisite for taxing income without apportionment, this fundamental tension between Congress's fiscal needs and the constitutional safeguards against unapportioned direct taxation will continue to define the limits of federal power.
Ultimately, listeners really have to weigh the benefits of allowing a robust, flexible federal taxing authority, one capable of generating massive revenue, often in a progressive manner, against the necessity or perceived necessity of constitutional limitations designed specifically to prevent arbitrary taxation on wealth itself. Clearly, the interaction between the 16th Amendment and the evolving nature of federal taxation offers far more to explore.